Welcome everyone to Responding to Financial Abuse Issues, Hardship Arrangements with Telcos, a webinar presented by Redfern Legal Centre. My name's Nick Manning and I manage the Community Worker Training Program here at RLC. Our presenter today is Will Dwyer. Will, would you like to introduce yourself?
Sure, thanks Nick. Hi everyone, thanks for joining us. My name's Will Dwyer. I'm a solicitor with the Financial Abuse Legal Service here at Redfern Legal Centre. We're the first specialist legal advice service on the issue of financial abuse in Australia, and hopefully we can assist our friends and colleagues in the support worker and financial counsellor space with these specific issues.
I'm just calling up the acknowledgement of country slide there. I would like to acknowledge the Gadigal people of the Eora Nation, who are the traditional custodians of the land that Redfern Legal Centre's offices are based upon. I'd also like to acknowledge that I'm on Darrigal land today. I acknowledge elders past, present and emerging, and extend our respect to other Indigenous Australians who are present.
Thanks, Nick. I'd also like to pay my respects.
Okay, I'll hand over to Will for the presentation.
Thanks. So the issue of financial abuse, I guess we will just provide a bit of background on what this issue covers, how to identify it, and then what are some practical ways that we can provide support to victims, survivors of financial abuse, particularly as they navigate dealing with telcos in this instance, but also any service provider. We are trying to promote better awareness from corporates in particular to recognise and respond to these issues when they are disclosed by customers. And there has been a lot of positive response to date from some of the major players in Australia, banks, telcos in particular. So there are quite a few options when it comes to negotiating with creditors or service providers to get around some of the particular issues that victim survivors face, particularly around their safety. So what is financial abuse? It's a form of domestic violence where an abuser uses money as a means to gain power and to control. Domestic violence is a pattern of abusive behaviour in an intimate relationship or other type of family relationship where one person assumes a position of power over another and causes fear, often referred to as a pattern of coercion or control. So there's no single agreed legal definition of DV in Australia, but it really covers a lot of issues. These are some of the behaviours which we see identified as a pattern when it comes to financially abusive behaviour. And a lot of it relates to how a joint liabilities or payments or other financial issues are used as a mechanism by one party to control another or to take the benefit of a particular finance arrangement, a credit card, a service, without making a fair contribution to the cost of that service. So we see it in both the control over finances in terms of not sharing joint finances, limiting one party's access to the joint income, quarantining things like social service and Centrelink income, and limiting one party's access to finances, which can often make it very difficult for a victim survivor to leave an abusive relationship without access to the funds to enable that. On the flip side, we also see a lot of cases where the abusive partner is using this coercion, control, manipulation in order to gain a benefit for themselves at the other party's expense. We see that particularly in our practice around credit arrangements where one party will coerce another to take on credit in the form of a loan, a credit card, or the accrual of a service. And they will make the other party liable for the cost of that service or credit, often by asking them to sign an agreement to put up their name as guarantor to take on the liability when in fact they may not actually be having the benefit of that particular liability. They are stuck with the costs, the debt, the adverse credit listings, and that financial hardship can often make it very difficult again to leave an abusive relationship. Some of the other indicators relate to control and scrutiny. In this context around telcos, that's a particularly relevant issue around concerns about the way in which telco services can be used to surveil, monitor, control one party, to really keep tabs on them, to make them feel as though they are under surveillance. And that is an issue that telcos are aware of, and there are some mechanisms to deal with. And there are other ways in which our clients and victim survivors can take steps to protect their own personal information and their own technology safety, which we'll run through a bit later in the presentation. So the situation with COVID has really made the issue of financial abuse worse. We've seen, particularly during lengthy lockdowns, these issues really come to a crisis point. We're seeing a greater demand for our service, but at the same time, it's also been more difficult for our clients to contact us discreetly where they are at home with a perpetrator of financial abuse or domestic violence. Opportunities for having time away from the household, whether that's at work or in other scenarios, is becoming more and more difficult. People are spending a lot more time in the household together. And that can make things, simple things like taking a phone call discreetly, making sure no one's monitoring your emails or messages coming through, more and more difficult. So we are conscious of that, and it just might be difficult for your clients as well to be comfortable disclosing these issues to you when they don't have the autonomy or safe space or freedom that they might have had before the impact of COVID. These are a few general warning signs for financially abusive behaviour, which your clients might not be aware of, but might be a trigger for you to consider whether they're a victim of financial abuse. These we've flagged a bit, but withholding financial support or making fraudulent applications for, in this case, social security benefits, where the victim will be making the application but not actually have the benefit of these payments because they're being quarantined. So these are a few things to bear in mind, specifically related to the current situation. So on to the substantive part of our discussion today about negotiating with telco providers in relation to financial abuse specifically. So these are the two kind of main guidelines which really are most helpful when it comes to making a case to a telco provider about their obligations and their public undertakings in terms of how they will support their customers. The TIO we will touch on quite a few times today, but they are the industry ombudsman. So they are the external dispute resolution provider for all the major telcos in Australia. If you are having difficulty negotiating with Telstra, Vodafone or Optus, they're really the main providers. There are a few others, second tier providers as well, which are often less well equipped to deal with these issues. My main advice would be don't hesitate to go to the TIO. Really, if you think you've hit a roadblock in your negotiations, go straight to the TIO because that really helps leverage your position, your client's position. The telco providers want to avoid the number of complaints that are lodged against them in the TIO. And they have also made these public undertakings as part of this Telecommunications Consumer Protections Code, which incorporates the Communications Alliance industry guidelines on customers experiencing domestic and family violence.
Sorry, Will, before you go on, I should just mention to everyone that those documents or links are all gathered together on our resources page on our website. So if you look at the address at the bottom of your screen, those links and all the links and resources that we'll refer to today are already gathered together on that page, as is this PowerPoint file. Thanks, Will.
Thanks, Nick. So this particular part of the TCP code, assisting customers experiencing domestic and family violence, is really the best guideline when it comes to understanding both the telco's obligation but also the customer's rights. And it goes into a lot of detail about how disclosures of domestic violence and financial abuse should be identified and handled by the telcos, as well as practical things which a customer can request and a telco can offer when it comes to resolving the issues around particularly mobile phone services. That's really the major issue that we see as a prevalent one. And there are some unique aspects to that service around authorised representatives versus customers, which we'll touch on a bit later. But my main piece of advice would be to consult this guideline at first instance, and that really is the best foundation of all the issues we'll be dealing with here, as well as the options available to clients and advocates. So these are the specific policies which each of the major telcos have made publicly available about their commitments to customers when dealing with domestic violence and financial abuse issues. The major players also have set up dedicated hardship teams to identify and separately manage these issues where they're disclosed by a customer. So the Telstra Safe team, you can see there, is a specific part of Telstra's hardship and customer management team, which has been set up to deal specifically with these issues where they arise. The policies each of the telcos provide kind of set out what their undertakings are, both in terms of protecting customers' privacy and safety but also dealing with the financial hardship aspects of billing, of handsets that can't be returned, of other practical options to assist victim survivors who want to leave an abusive relationship, but find this telco service is a barrier to being able to do that. So if your client identifies a specific service check-in with both the TCP code and the guidelines on financial abuse, and then the company's specific DV policy. As I mentioned, some of the second tier mobile operators in Australia probably have less help and information when it comes to these specific DV policies, but they are required by the TCP code to have a DV policy in place and a hardship policy in place. So it should be publicly available. So this is just an overview on our thoughts about what best practice in responding to DV and financial abuse and financial hardship policies should cover. One of the key issues we hear from clients and from community workers and financial counsellors is where the customer has disclosed the issues around DV and financial abuse to their telco provider, and then they're asked for evidence, some proof that they are in fact a victim of DV. In our view, that is not best practice, and it's not something that telcos should be demanding or insisting on. Specifically, the request for an apprehended violence order, IVO, in other states, that is not always in place, and it's not always appropriate for victims of DV and financial abuse to feel comfortable taking that step. So in our view, really the simple disclosure by a customer that they are a victim of DV and financial abuse, and some form of supporting document that might be a letter from a caseworker, a financial counsellor, really that should be enough. And it's often easier where a client has an advocate supporting them. But we want to push back where we hear telcos demanding a copy of an AVO before they will offer any kind of hardship assistance, or either an AVO or a family court order. Really, in our view, it's a very difficult thing to disclose, and that disclosure in and of itself should trigger, the appropriate response through the hardship policies and the DV policies of the company. But dealing with customer service for telcos, I'm sure we've all had our frustrations. I know I certainly have in dealing with the telco customer support phone lines in particular. Long waiting times, very difficult really getting to speak to the right person, and often not great customer service. So we'll go through a few options and hopefully helpful tips to make sure that our clients' hardship cases are getting to the right part of the company. And a simple way to do that from the outset is to make this disclosure of domestic and family violence and financial abuse as soon as possible, and to make reference to things like the company-specific hardship policy around family violence. And when advocates are supporting to get the authority to act process registered quickly so that they can speak with hardship representatives quickly and avoid the rigmarole of calling up the standard customer service hotline which often just leads to a lot of time wasting and not the best results. So we'll try to touch on a few of these tips to get your complaint to the right part of the company. So this is what I was mentioning, that we've all dealt with the call centres for telcos. Often they're offshore. Staff training is often underwhelming. There's not a great recognition of DV and financial abuse. They might ask clients inappropriate questions about their experience, which can lead to reliving trauma and not a trauma-informed way of communicating with victim survivors. So we recommend that where possible, to begin these communications in writing, so that you both have a clear record of what exactly has transpired in terms of disclosures and offers of assistance, getting the authority on record as soon as possible, and to push back on requests for evidence of DV, noting that the TCP code and the guidelines on financial abuse make this clear, that telcos can't demand this, and that in many circumstances it's inappropriate for them to insist on it. So a lot of the telco related issues we see will relate to a phone plan. So that's a postpaid plan, often with a payment to pay off a handset, an iPhone, which might run as a contract for 24 months is typical. So it's a form of credit, and it has an ongoing payment obligation for the term of the contract, which can often be significant, hundreds of dollars per month. And we see scenarios where victims will take on liability for these postpaid contracts for a handset for the perpetrator of DV and financial abuse. That's a common scenario we see play out, where parties will go into a telco store. They might sign up for 2 plans, maybe even plans for their kids. Often it will be the victim's name as the authorised representative on the account. They take on the financial liability for payment of the total amount, and it might be that undertakings to contribute to that cost to pay their way when it comes to the cost of a phone service are not met. And there can be significant costs when it comes to both managing the ongoing payment, but also trying to cancel a contract, to alter a contract, to deal with the ongoing liability when a victim survives trying to leave an abusive relationship. So we'll touch on a few of the options that telco providers can offer when it comes practically to dealing with phone plans in particular. Prepaid plans are often more straightforward. It's not an ongoing liability. There's just a simple payment in advance to access the service, often with clients bringing their own handsets. So one option which is often made available by telcos is for a victim survivor to cancel their postpaid contract, to deal with the handset in a few ways. We'll touch on that again shortly, but to transition to a prepaid arrangement, often with some free credit. The telcos as part of their response to DV and financial abuse, are quite good at offering things like prepaid credit to help a victim survive and move on, as well as dealing with the cost involved with the handset, occasionally making handsets available for free, but quite often waiving the cost associated with paying down a handset where our client and the victim can no longer manage the ongoing payments, or the burden of that is making it difficult for them to leave an abusive relationship. The other issue we often see is around who is the authorised representative versus customer on the plan. So the contract will only be with one party, but there can be multiple services under one postpaid contract. So we often see one party taking on liability for, say, 2 or 3 handset and service costs over 24 months. And if they are trying to leave a relationship, the issue around having to continue paying for their ex-partner's phone service and the implications if they want to cancel that contract are often one of the most common issues we see playing out. And the telcos have been pretty good when it comes to figuring out practical ways to deal with this issue and offering clients the option when it comes to trying to resolve this issue, particularly where the perpetrator of DV or financial abuse has a handset which our client or the victim is paying for. There is scope for the telcos to write off the costs associated with that handset, to cancel the service if that's what they want to do, or to take that customer off as a party to their contract and set up a separate arrangement for them to deal with that handset and the service cost separately. That is something which the hardship teams can do on request, and they're pretty good around managing the complications of multiple phones, multiple handsets and services which are in one party's name. On the flip side, we also do see clients where the other party is the authorised representative on the contract, and they are simply a customer. So typically their requests to a customer service staff member at a telco will be rebuffed, and they'll be told that as they're not the authorised representative, they can't port out their number to a new plan, or they can't make separate arrangements to deal with the cost and ongoing service. So the DV trained hardship teams at the telcos are now much better equipped to make arrangements to separate out these contracts where a customer has identified that they're a victim of domestic violence and financial abuse. So they can both create new agreements, prepaid, postpaid contracts, help you to deal with the cost of the handset, whether that's the client's handset or the ex-partner's handset. They can write off some of the costs associated with that in certain circumstances. They can shift customers from postpaid to prepaid contracts, and they can create separate accounts and phone numbers. So creating a new private number, which the other party doesn't have access to, is a critical step often for safety planning. And the options available to clients when it comes to trying to negotiate a fresh start. The telcos we've been quite happy with the way in which telcos will often help practically to work with the client and figure out a way in which they can continue to have access to a mobile phone service, which is essential, but ensure they have a new private number and have a practical way of managing the costs, both the ongoing cost, but also any liability connected with the services to date. The last point also touches on dealing with the perpetrator's phone. Giving the client the option with how they think is best to deal with a perpetrator's phone service, whether that's disconnection or not, or whether that's separating that particular number from the account, or whether the telco should provide any warning or have a discussion with the perpetrator about either disconnection or separating that service. So that is ultimately the client's call to make, and they will be able to tell you and the telco what arrangement they feel comfortable with in terms of dealing with the perpetrators, both phone and service.
Sorry, Will, we've got a number of questions around plans. Would you like those now, or will I hold them until later?
No, let's answer a few now.
Okay, so Sonia asks, have you had any experience with clients whose handsets are getting smashed by the perpetrator? If the handset's under contract, this can cause serious financial hardship. Yeah,
and that is a common issue, the damage to a handset, and a handset being lost or stolen or quarantined by another party. So where a disclosure has been made about that to the telco, they are required to offer financial hardship assistance in managing that ongoing cost. They are often, when you are through to the financial hardship team, who are DV trained, they are often good, where that disclosure has been made about making arrangements to either write off the cost in full, to reduce the liability outstanding, or to roll it into an ongoing payment plan to pay off the cost in the future by installments, as well as to make other options available for accessing a service, both the cost of the call and text service itself, but also getting access to a handset. So there is a pretty broad discretion when it comes to the responses that you can expect from the hardship teams, but they have, given that the debts associated with these services might be $1,000 to $2,000, quite often is not uncommon, but the hardship teams have a pretty broad discretion to write off amounts up to around $2,000 without requiring too much evidence where disclosures around DV and financial abuse have been made.
Okay, Di has a question around evidence. She says that Vodafone's asking for a stat dec from her client. Can they insist on receiving this statement before they remove the client from the perpetrator's account?
Yeah, we see that request quite often in terms of some kind of verifiable statement from the customer around their experience where they don't have an AVO or they don't have a third-party support organisation verifying. And we're generally okay with our clients making a statutory declaration. It is a simple way for them to put on the record what their experience has been, and that is enough quite often for the telcos to work with when it comes to making decisions around waivers, writing off debts associated with lost or damaged handsets, So in short, yes, they can insist on a stat dec, and we think it's not too onerous for a client to complete that.
Okay, someone asks, will a client be allowed to keep the device if they go on a prepaid plan?
In short, I think yes, provided they can negotiate that with the telco. Quite often, particularly if there are other indicators of financial hardship, not having access to income or reliance on Centrelink, or having access to matrimonial assets, quarantine during family law disputes. Quite often the telcos can write off, the remaining balance when it comes to handset payments on a contract. And that's all part of ensuring the customer has ongoing access to both the handset and the service. Or they can often, write off proportional amounts of the handset. But the customer will have to demonstrate some financial hardship quite often.
Okay, you just used the word quarantine, I think, in the family law context. Someone asked earlier what that means. Did I hear that right?
Yeah, so that's where one party, the perpetrator of DV or financial abuse, might have control over joint incomes, bank accounts, signing rights over certain assets. There might be all the family or matrimonial assets tied up in a company of which they are a director and a sole authorized rep. And we often see clients who are only paid, an allowance or a stipend, even though they might be contributing their income to the joint asset pool. So it comes down to, practically what access our clients or customers have to income, to credit, or to a way of managing their living expenses. In the family law context, we see it where there's a long drawn out dispute around access to these assets, where they might be controlled by the ex-party, but until a family court can make orders around how they should be dealt with after separation, which can take a long time. We see clients who might have income and assets on paper, but not, in fact, have practical access to them. So that's what I was referring to.
Okay, thanks. Another question. Someone asks, we're seeing lots of women with multiple phone contracts. Is there any scope to limit the number of contracts one person can have?
Yeah, it's a good question. So particularly where there are either family arrangements for multiple handsets under one kind of authorized representative account. There is, guidelines in the TCB code around kind of assessing the suitability of various applications for phone plans and handsets, which is often not done particularly well by telco representatives in store. They will often run credit checks to figure out if someone can manage, the ongoing costs associated with, several handsets, high-end iPhones, and expensive plans of, $100 plus a month. But they quite often, unless there is issues with your credit report in terms of affordability, I don't think there's a broad discretion for a telco or service provider to refuse or to suggest that you don't take on multiple handsets or phone plans unless there's an issue with your credit. So it is a problem, and particularly where there is this manipulation or coercion for the victim to take on liability for the whole family's telco costs and to take on costs associated with higher end phones, which are very expensive and lead to more significant debts accruing. But it's difficult at that first kind of point of sale to flag or identify these issues, but the telcos are on notice, and that should form part of their training, particularly where these financial abuse indicators are more obvious, or there's other indicators around consumers genuinely understanding the nature of the agreements that they're entering into, or whether there's any obvious kind of undue influence or duress, which should be a red flag.
Okay, Bill asks, are we entitled to obtain a copy of the credit assessment conducted by the telco?
Good question. I don't know the answer offhand. If a complaint went to the TIO, that might become material and they might have to disclose it to the TIO through that process. But if it is a right that a customer has, then an advocate also has the same right when it comes to dealing with a complaint or a hardship request on their behalf. But short answer is I don't know offhand.
Okay, another question. Under what circumstances will the telcos allow a cancellation of, say, a 12-month or 24-month phone contract, especially where physical phone is part of the contract, but the handset is not in the hands of the person who's paying the contract?
Yeah, it's a common scenario, and there's a broad discretion in terms of the financial hardship support generally that telcos can provide. But if you don't ask for it as a customer or as an advocate, they won't always offer it. So it's worth asking for when you've begun the hardship application for a write-off of the outstanding balance and for any debts associated with the handset to be written off. You might not always get that at first instance, but certainly where there are serious issues around DV and financial abuse, and you can point to this debt and the ongoing service liability being a barrier to someone leaving an abusive relationship, that is often where we see the hardship teams being more supportive. They understand that, this is a relatively small amount for the company. The hardship teams have a discretion when it comes to making decisions around write-offs, both for service costs and for handsets. And they know that this issue around either handsets being damaged, lost, stolen, or taken from the victim by the other party are fairly common. There is also scope for them to block and disconnect handsets where the other parties have taken them and are using them for their benefit. And even though they might not be able to have the handset returned, they can still often block the service or the IMEI number, I think it is, to make that handset bricked or redundant if that's an outcome the customer wants.
Okay, maybe one more question now. There might be time at the end for a few more, but this one's about Telstra vouchers. What options for clients now that Telstra vouchers are discontinued? Envisage delays, re-client connection, increase of debt and more time involved for financial counsellors. Was useful tool to alleviate client financial stress and a quick step that strengthened engagement and aided in confidence in ticking off one item to ease the process. So Telstra vouchers discontinued.
So I'm I am not that familiar with the voucher scheme at Telstra, but I do know they have now discretion not to issue vouchers up front to help with the cost of bills, but to make decisions around writing off amounts of debt which is unpaid as a result of contracts. So I think they can offer a similar resolution, but rather than giving you credit towards a bill, they will be able to write off an amount of debt associated with a service or contract when you make these disclosures to their hardship team. And from our experience, they can write off often the total amount of the debt or a significant portion of it, particularly where you can make it clear to them that this debt and the ongoing cost of the service is a barrier to a victim survivor of financial abuse from leaving a relationship. So highly recommend making that disclosure if the client is comfortable and pointing out to the hardship team at the telco that the client can't afford the debt, and because of this debt they don't feel comfortable moving on. That's been very effective in our experience.
Thanks, Will.
So I'll just move on to the next slide, and we've covered a bit of this already around handsets in particular. So it's worth identifying from the outset, is there a handset cost associated with the phone plan? What are the costs both for cancelling the service as well as making the handset payments when it comes to trying to resolve the contractual issue? So telcos will often agree to write off the handset cost if the handset can be returned. They will send you a reply paid envelope to send the phone back, but in many cases that is not practical. The handset might be lost, stolen or damaged. We make mention there about insurance. If there's an insurance component on the handset, they will often ask that a claim be made with the insurer for repair or replacement first. Then the client can return the handset. But in scenarios where the perpetrator has the handset, or it's not safe for the client to recover it, or it's been damaged as a result of a pattern of abusive behaviour, then the telcos have discretion and, from our experience, are often amenable to waiving the outstanding handset fee. That's a cost to them, but as part of their corporate social responsibility on this issue, they're happy to take on that when it comes to assisting victims of DV. But it does require some negotiation with the hardship teams to make that happen. So I'll touch a bit on safety here and dealing with unwelcome contact. This is probably a separate topic in and of itself, but it is very relevant when it comes to dealing with telco services in the context of DV and financial abuse. And there are a few self-help kind of options that your clients and our clients can take when it comes to just helping to protect their personal safety and their personal information when using mobile phones and the internet in particular. I highly recommend the Women's Safety, Technology Safety and Privacy Toolkit. See the link there. That is probably the best resource I've seen in terms of proactive steps that someone can take to check their personal safety, do a kind of personal safety and online health check to take proactive steps to improve the privacy of their personal information, or to deal with scenarios where they are victims of harassing, stalking, intimidating behaviour using a telco service. If that has been the case for your client, that they've been subject to a pattern of unwelcome communication, repeated phone calls or abusive text messages in particular, telcos can take some action where the customer has made a report to them about a pattern of unwelcome communication, so they can conduct investigations and do things like block services where that abusive contact is coming from. The telcos can only take action against the unwelcome contact that is happening through their services. So that is really just phone calls and SMS. They can't take action where this is through third-party apps like Facebook Messenger, WhatsApp, even Apple iMessage. So they are using mobile data for the communication rather than the telco's service. So for unwelcome contact through those platforms, you'll need to help the clients to make a complaint or to take proactive steps around, blocking particular people or reporting conduct through Facebook. So Facebook will cover Facebook Messenger and WhatsApp. Apple iMessage will cover complaints about iMessage. And this link here is about some self-help steps you can take through Facebook specifically for blocking unwelcome contact.
Will, just on that, is there a way a victim can retrieve unwelcome text messages that have previously been deleted? Be a question.
Good question.
Telcos, I imagine.
Yeah, so telcos, I imagine, I don't know offhand, but they will probably have, I think, a call log and text message record in their service. I know they have to make those things available for law enforcement when requested to do so or ordered by court to do so. Where it comes to other third-party apps, once something is up there on the internet, it's probably likely there's a record somewhere, but to retrieve it, you would have to go through the process for making a specific, information request through Facebook potentially or Apple, which I'm sure there's a process that's probably complex, but it's fairly likely, in my view, that there will be an ongoing record somewhere. The advice we give to clients is always to keep records of these types of communications, whether that's through downloading the message or taking screenshots, trying to make sure that record is time stamped, so it has the date and the time, and that can be used in a range of complaints, both in this context, but also for making applications for protection through AVOs and things like that. That's a common scenario where this kind of evidence is really critical, as well as in the family law context. And generally those kind of SMS, Facebook Messenger or other type of chat records are admissible. But the question is around verifying that what was sent between two numbers was done at a particular time or by a particular person. It comes down to just having really good records. We also recommend to our clients that they keep a separate kind of written journal or log about unwelcome contact and interactions, where they make a separate record around each and every time unwelcome contact has happened and what it's involved. And that really helps to establish this pattern, which is helpful both in this context to get help from your telco, but also when it comes to verifying this behaviour to other authorities or courts.
Thanks, Will.
So I might pause and see if there's any other questions on the telco aspect. And if we've got a little bit more time, we can just touch briefly on the utility provider context. I know we're getting close to time.
Yes, I do have a couple of questions. You may have already covered some of these, but what are the circumstances, if any, where consumers can get out of planned digital device contracts? Has that been covered?
Yeah, so a plan with a handset component is really the most common telco service we see, but there is a very broad range of circumstances covered loosely under the definition of financial hardship, as that's disclosed in the TCP code. And the experience of domestic violence and financial abuse is an indicator of financial hardship. And where that's been notified to a telco provider and there's been evidence that is enough to support a request for financial hardship responses, whether that's making alternative payment arrangements, writing off a debt, writing off a handset debt, as well as practical help around getting a new number, getting set up with a new service, getting a prepaid service or prepaid credits. They're all things which the telcos are getting better and better at dealing with, and particularly through their hardship teams, which have been trained to identify and respond to domestic violence specifically.
Okay, another question is about business plans and accounts. Are there any exclusions due to the commercial nature of these types of contracts? I assume they mean, are they covered by these same DV policies?
Yeah, I think broadly, yes, they are. There is some issues around identifying who's the authorised representative on an account, but it's pretty common for clients to have an ABN number and to get the benefit of a business contract. But at the same time, that doesn't prevent them from being a victim of DV and financial abuse. So in our view, that shouldn't form any barrier. It's not really a different service. It's just a slightly tax advantageous arrangement. If you were having issues around that and you were getting some pushback from the telco, I'd suggest getting a complaint on with the TIO. And we see it in the context of clients being made shadow or puppet directors of companies, often to run a family business, where they're taking on the liability as a director, but not actually having much involvement with the day-to-day running of the business. So that is one thing to bear in mind about who's the signatory or the authorised rep on a business account. Often it will need to be someone nominated as a director of the business.
Okay, we've only got a couple of minutes, so I should mention the slide there about utilities. That was a bonus extra, which we were going to present if there was time, which there isn't. But we'll, I might ask one final substantive question, and then there's a couple of questions about your service. So Leah asks, if someone has left the household or is now away from the perpetrator, is there a time limit for accessing these sorts of supports, given the clients often need some time away before they are ready to face these issues? Like it could be more than a year later.
Yeah. No, that shouldn't be a barrier. The only issue, I guess, is the ongoing accrual of the debt and the liability. But it does take time often for our clients to get the comfort to deal with these issues. But it can be applied retroactively, can be explained as though the accrual of a debt over the course of several years is as a result of DV and financial abuse, but there's no kind of statute of limitations or time limit that a telco has to offer hardship, or a limit on the number of times you can ask for hardship. If you've had hardship assistance in the past, it doesn't prevent you from accessing it again in the future. Okay, thanks. Perhaps, Will, you could progress to a later slide that has the resources link on it. Yes.
one more, I think.
Okay, so
those
that's
sources are
for
on our
utility
resources page.
specific. Yeah.
Okay, yeah. There's a question about, yeah, thank you. So our resources page is at the bottom of the screen there, and that has a wealth of links and resources around all aspects of financial abuse. So I suggest you have a deep dive into that. So questions about your service will, and the first one is, do you have contact details for the hardship departments for the major telcos? I can't recall if they're already on our page, or is that not publicly available?
I included links to the policies there for each of Telstra, Optus, Vodafone. Sometimes they will have an email link for a hardship department specific for DV, but quite often you'll need to start with a phone call first. And then when you go through providing authorities and other written submissions, they will give you an email address. They don't make it easy to find, but if you do a bit of creative Googling, you can often get a contact. Occasionally it takes some time on the phone though.
Okay, thanks. And so we've got a couple of questions about your service, and perhaps take the opportunity to generally describe the financial abuse service at Redfern Legal Centre. But the particular questions are, do you assist with claims issues with insurance companies, particularly car insurance? And the other question is, do you assist with complex financial abuse through fraudulent trusts, directorships, ATO debts, etc.? This is Sonia, and she has a client whose perpetrator is a financial planner, and they're using every available loophole to make it difficult for the client around child support, etc.
So our service is a statewide service for clients in New South Wales. We also provide kind of phone a friend assistance to support workers and financial counsellors who want to either refer clients to us or get advice they can pass on to their clients. We have really two major aspects of the service. The first is credit and debt issues. So that relates broadly to the insurance question you answered. We have covered some tax issues and can get advice from some of our partner organisations for tax specific issues. We see a lot of other issues around company directorships, as I mentioned, and other, superannuation is another one. But pretty much anything broadly related to a financial service, we can provide advice on. We can't always undertake to take on every case, but we can certainly scope it out and do our best to provide initial advice. We also have a family law accredited specialist with our team who provides advice on the family law aspects of financial abuse. We can often set up a co-advice appointment, which will cover both family law and credit and debt aspects in one appointment. So it's a pretty broad range of issues that we can cover. And we have partnerships with some law firms and corporate firms who also occasionally take on pro bono briefs for us for the more complex and involved matters.
Okay, thanks. Perhaps, Will, if you could go to the next slide, I think it is, and I thank you, that one. So Margaret tells us that Financial Counselling Australia has the hardship contacts in their toolkit. So I will endeavour to dig that out and put a link on our resources page. Emily asks, what's the referral process to your service? And I can say that those details are already on our resources page. We provide a phone number, a web form, and I think an email. So there's multiple ways that clients or workers can contact the financial abuse service. And of course, all necessary safety measures are in place around that contact. I think that's all we've got time for, Will. Thank you very much. That was very informative. And thank you to all our participants across Australia for your attention and interest and your questions. I should mention that we did record the webinar, and that recording will be up on the resources page, hopefully even today, but very soon. Thanks, everyone.